The president of the Law Association of Trinidad and Tobago, Senior Counsel Lynette Seebaran-Suite, is expecting efficiency in the judicial process since Parliament has done away with the preliminary inquiry procedure at the Magistrates Court. More in a story compiled by Vivian Bowen.
A legal proceeding that has been considered outdated since the 1960s by then Chief Justice Sir Hugh Wooding has finally been abolished. That is the message put forward by the head of the Law Association of Trinidad and Tobago, or LATT, Lynette Seebaran-Suite, Senior Counsel, when she referred to the proclamation of the Administration of Justice Indictable Proceedings Amendment, or AJIPAA, and the doing away of the preliminary inquiry from the court system. Speaking at her office on Woodford Street, Port of Spain, Ms. Seebaran-Suite says initially there would have been resistance in some quarters to the change, but she points out that there was and still is a great deal of preparation, consultation, training and changes to the judicial system that have been facilitated by the Attorney General's office.
There was a significant innovation where the courts, the term district judge has replaced the term magistrate. The magisterial districts have been reorganized, and most importantly, you now have masters on the criminal side to deal with all of the preliminary preparatory work.
The LATT president notes one change that comes along with the AJIPAA legislation.
You call it just AJIPAA, is that evidence can now be presented in court digitally. Prior to the proclamation of this act, actual physical exhibits, whether it be drugs, whether it be guns, whatever was the subject matter of the crime, had to actually be kept in the custody of the police and then had to be physically presented in court.
She expanded on the new arrangement.
But that has now been done away with because photographs and video can now be taken, and so all this whole question of the chain of custody and the disappearance of physical evidence has been eliminated.
Ms. Seebaran-Suite says that the AJIPAA system would also lessen the stress on witnesses.
Because you can well imagine that if a matter is pending in court 7 years, 8 years, witnesses go away, they die, they become unwilling, they lose interest, and more importantly, they forget.
However, she notes that because there are now 3 ways for an indictable offense to start, more strain would be put on the Office of the Director of Public Prosecutions.